pipes are calling from glen to glen and down the mountainside. The summer's gone and all the flowers are dying. 'Tis you must go and I must bide. But come ye back when summer's in the meadow, or when the valley's hushed and white with snow. 'Tis I'll be there in sunlight or in shadow. Oh, Danny boy, I love you so.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
Test 1 2, check mic test 1 2, check mic test 1 2, checking mic test 1 2, check mic test 1 2, check mic test 1 2, Want me to just keep going to the next one? Yep. Check mic test 1 2. Check mic test 1 2. Check check. Check mic test 1 2. Check mic test. Check check. Check mic test 1 2. Mic check test 1 2. Check 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 1 2. Can you hear that one okay through the room? Yeah, this one sounds pretty low. Test test. Check test test test. Test, test. Mic check, test, 1 2. Mic check, test, 1 2. It's coming through, it's just, I think, yeah, it's on the low end. Does that need to be changed on the mixer?
Nothing's changed. Yeah, just use the other mixer. Okay, go ahead and talk in.
Okay. Check, check. Mic test, check, 1 2. Testing, mic check, 1 2. Test, test, mic check, 1 2. Mic check, test, 1 2. Testing, testing, testing. Mic check, 1 2 3 4. Check, check. That good? Is that, oh, that sounds a little better there. Ready for the next one?
Yep.
Okay. Check, check, 1 2. Mic check, test, 1 2. Check, 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 1 2. Testing, mic check, 1 2 3 4. Test, test, 1 2 3. Mic check, test, 1 2 3 4. Testing, testing, 1 2 3. Testing, testing.
Okay.
Mic check, test, 1 2. Mic check, test, 1 2. Testing, testing, mic check, 1 2. 1 2 3 4. Testing, mic check, 1 2 3. Testing, mic check, 1 2 3. 1 2. Testing, testing, 1 2 3. Mic check, test, 1 2 3. Testing, mic check, 1 2 3. Testing. Testing, mic, 1 2 3 4. Mic check, test, 1 2 3. Testing, testing, 1 2 3. Testing, mic check, 1 2 3. Testing, 1 2 3. Mic check, test, 1 2 3. That one's a lot louder than the other ones. Test, test, mic check, 1 2 3.
Okay.
Good?
And then there's two handhelds on the table there.
Test, test.
Morning.
Testing, testing, mic check, 1 2 3. Testing, mic check, 1 2 3. Testing, mic check, 1 2 3. Testing, testing. Testing, mic check, 1 2 3. Testing, 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 mic check, 1 2 3. Testing, testing, mic check, 1 2 3. Testing, mic check, 1 2 3. Testing, testing. Testing, mic check, 1 2 3. Testing, mic check, 1 2 3 4. Testing, testing, mic check. Testing.
of the coming of the Lord. He is trampling out the vintage where the grapes of wrath are stored. He has loosed his faithful lightning of his terrible swift sword. His truth is marching on. Glory, glory, hallelujah. Glory, glory, hallelujah. His truth is marching on. Hallelujah. Glory, glory, hallelujah. His truth is marching on.
This next song is written about losing someone that you love. Step outside with me and look for a star as we play Dust to Stardust.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com. You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com. You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com. You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com. You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
pipes are calling from glen to glen and down the mountainside. The summer's gone and all the flowers are dying. 'Tis you must go and I must bide. But come ye back when summer's in the meadow, or when the valley's hushed and white with snow. 'Tis I'll be there in sunlight or in shadow. Oh, Danny boy, I love you so.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com. You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
of the coming of the Lord. He is trampling out the vintage has loosed his faithful lightning of his terrible swift sword. His truth is marching on. Glory, glory, hallelujah. Glory, glory,
This next song is written about losing someone that you love. Step outside with me and look for a star as we play Dust to Stardust.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com. You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
The Supreme Court of the State of South Dakota, the Honorable Chief Justice Stephen R. Jensen presiding, is now in session.
You may be seated. Thank you. Good morning. We're once again pleased to be here at Augustana University for our March term of court. And we appreciate Augustana being great hosts for us this week. We have 3 cases set for argument this morning, and after we finish our 3rd case, for those of you that are here in the audience, if you want to stick around, and we'd welcome you to do that, we're going to have an opportunity for question and answer time afterward. We can't talk about the cases that have been argued this morning, but just general questions about what we do as a court and how our court system works. We'd love to have an opportunity to dialogue with you when we get done here this morning with our 3 cases. So with that, the first case for argument this morning is appeal number 31100, 31144, Viva Capital versus Jerry Garrett et al. Nicholas Novi will be arguing on behalf of Jerry Garrett, and Kwai LeQuain will be arguing on behalf of Viva Capital Trust Corporation. With that, each side will have 15 minutes for your initial argument, and then Mr. Novi, you'll have a 5-minute rebuttal. You can proceed, Mr. Novi.
Thank you, Your Honor. Excuse me.
It's a little short.
It is. I'm doing my best. Good morning, and may it please the court. My name is Nicholas Novi, and I represent the estate of Frank Garrett Jr. on this appeal. For over 100 years, South Dakota has prohibited human life wagering. They've done so through their constitution, through statutory prohibitions, and through 100 years of case law that suggests South Dakota courts and trial courts should be piercing the disguise of these transactions and not just looking to the mere form of the transaction. Now, there's no dispute here that if United National Funding, the third-party investor in this case, were to go to Florida and pick out a senior citizen by the name of Frank Garrett and procure a policy on his life and name United National Funding, the bank, as the beneficiary, of course that would violate the insurable interest statute, and of course that would be an unlawful wager. So the question before this court here today is quite simple. Can United achieve that result indirectly through the creation of a South Dakota trust to conceal what's really going on? These transactions, these indirect transactions, are known as STOLI. Stoli is where strangers originate the policy, fund the policy, all for the benefit of other investors because they're trying to create an investment vehicle. And the insureds in these cases are instrumentalities. They're straw men. Now, the validity of whether Stoli is legal across the country is usually turned on one simple fact. Are courts willing to pierce the disguise of the transaction and figure out what really happened, or are they just going to look at the forms? Look at the forms of the documents that the transaction are printed on.
And I want to stop you just for a moment. Just an ad hoc question on, I think you referenced in your brief that, maybe the trust was formed here in South Dakota because there's less regulation or something like that. Is there any evidence or do we have anybody telling us why this trust ended up being set up in South Dakota?
So, thank you, Justice Jensen. The answer to your question is a little bit twofold. First, there is evidence in the record that these investors targeted South Dakota because they believe South Dakota would be beneficial for them.
And where would we find that in the record?
I can certainly get that cite and have it for you on the reply, Your Honor. But to answer your question as to why, it's a little bit more muddied as to why, but at the very highest level, they thought they could get away with their Stoli scheme and their human life wagering by using the South Dakota trust to conceal what's really going on.
Because you have a limited amount of time, counsel, I just want to, so there are a couple issues here, and there's been this, the court, part of its basis was that the challenge to the trust itself could not be brought because of our statute of repose. And I know there are different arguments by both sides on that, but in the event that is true, does at least one of your counterclaims still remain, even if we did not, couldn't refer to your claims as to why the trust itself?
Thank you, Justice Devaney. I appreciate the question. So the statute of repose here doesn't apply for three simple reasons. The first is it wasn't even enacted until after this trust had long terminated. So the statute wasn't enacted until 2010. This is a 2006 trust that held no assets whatsoever, only this life insurance policy, which was then relinquished in 2009.
Does it matter the fact that the insured died, and that's the trigger point of the 1 year after the statute was in effect?
Sure. So I think if I understand your question correctly, you're asking because the insured did not pass away until recently, and therefore the statute was enacted. I mean, our reading of the statute is quite simple. It's meant to, the purpose of the statute is meant for a trust contest. It is meant to the efficient distribution of trust property. Here, that is not what this case is about at all. We're not seeking any trust property.
Well, I'm going to stop you there. The actual statute refers to a judicial proceeding to contest whether an irrevocable trust was validly created. So that seems broader than what you're claiming.
Understood that the statute language is rather broad. I was simply making the point that this court has long held that the purpose of the statute is about efficient trust distribution. And to answer your question really directly, Justice Devaney, our case is not predicated on the invalidation of this trust at all.
That was my primary question.
The crux of this case is about the insurable interest statute and applying the insurable interest statute to the facts of this case. And going back to how the trial court, going back to one additional point, is that states that have constitutional prohibitions and strong common law that suggests that courts should be piercing the disguise of these transactions have almost all uniformly held that Stoli is illegal and that it's a fraud on the court and that it's a human life wagering scheme. Now, trial court Judge Hoffman erred here in multiple respects. Didn't analyze the statute correctly, didn't give meaning to the words of the statute. He also didn't really conduct a thorough factual analysis of what really went on here. He didn't pierce the disguise of the transaction as this court has long held trial courts.
Can I hold you up there for just a minute? So are we talking about two things there, and do you need them both to win? Here's what I mean. So is it possible that Judge Hoffman read the statutes exactly right? I know you don't say that, but is it possible that they do in fact operate as he said that they operated? But nevertheless, you see a public policy issue that's in tension with the entire Stoli concept. This piercing that you keep referring to, you know, we have cases, in fact, recently, no one cited it, but there's an equitable mortgage case called Sturgeon-Becker, where we held, look, there's a lease, there's a buyback, there's a loan, there's all this stuff, and, you know, it's not called a mortgage, but we can look at it, we can say, you know what, that's a mortgage. And you have to give someone redemption rights, and you can't outflank their redemption rights. When you say pierce, is that what you're talking about? And if it is, what difference does it make if there's technical compliance, if what you're really asking us to do is look at the substance of this and say, what is it?
That's exactly right, Justice Salters. We're absolutely asking this court to look at the substance of what went on here, and that's how we think the trial court erred. However, we do think a relatively plain reading of the statute, which does require statutes to be read in harmony, and I'm happy to talk more about that, and to interpret the statute in a way that is consistent with the Constitution and consistent with with general statutes prohibiting wager. We think
it seems like, and maybe I thought you kind of conceded this, but maybe I'm wrong. I thought you, in your initial statement, you kind of conceded, if you look at the plain language of the statute, you know, there's an argument here that there was an insurable interest for Jerry, and so I thought you kind of conceded that, and we have to do more than just look at the plain language, as I understand your argument.
That's right. I mean, look, to keep this really simple, Your Honors, is the substance, the real question before this court is whether it's going to apply form over substance or substance over form. And that's really the delineating factor in all of these Stoli cases, is whether courts are willing to pierce the disguise of the transaction, ascertain the true activities involved. That's from this court's decision in Waite v. Frank all the way up in 2009, this court's decision in Nev versus Davis. The same principles apply here.
I understand that argument, because I mean, I think you could make, you don't have to concede it, I won't put you on the spot that way, but there's a pretty good argument under 5810-4-6 concerning the trust and the insurable interest of the trustee. It's not a throwaway argument. What Judge Hoffman said, and what he decided, and how he read it.
So if I may address that?
By all means, yeah.
So going right to the statutory language, right, 5810-4, 5810-3 talks about procure cost to be procured unless the policies are payable. I think, Justice Salter, your question is directly related to, you know, can a policy have insurable interest if it has a trust with a beneficiary that's named a family member? And the answer is no, for several reasons. You know, the first is that this idea that the family may have received some money at some point is exactly the promise that induced Frank to participate in this scheme from the very beginning. It's exactly that promise of possible future financial compensation conditioned on what? Conditioned on his death. That is part and parcel of the wager. Back in the old Stoli days, Stoli promoters would try to induce senior citizens to engage in these transactions by giving them cars or watches just to sign on the dotted line. But here, this is even more so a wager because the policy, because United was interested in his early death, but only if Frank survived the first 2 years, so that it could obtain the policy on his life.
Go ahead.
Well, you know, and it appears there was, you know, facts produced, and I think there was a record question by the chief, and I think it was someone that worked for United that kind of explained how the whole thing went down. But there's quite a vetting process in who they're gonna target here: a certain age, certain medical history, what is the likelihood they're gonna live past 2 years, but maybe not so much longer after that, and a lot of features that went into this. It also appeared to me from reading all the cases that these programs have kind of evolved as the court rulings started coming down. So this current one, and it, you know, it seems like the latest iteration is to have very specific 3 different options of what happens when your loan comes due. And the likelihood that you're going to be able to assume the premiums is probably slim to none. But the fact that there are these other options in these programs, does that at all come into play? And if so, how, as to whether or not this is truly one of these schemes that was designed to result in the insured person never having, or an uninsurable interest entity ending up with it.
Understood. Thank you, Justice Devaney. And I would say this simply, the fact that the insured had these technical, hyper-technical options that they were never real options and they were never, the insurance itself was never intended for any insurance purpose. It was intended as a wager. And the fact that it's possible, hyper-technically, that Frank could have somehow funded this trust. Remember, Frank was not even the borrower of the loan. First and foremost, the trust was the borrower of the loan. The trust had absolutely no assets. But putting that aside, you know, all these Stoli programs, as you allude to, Justice Devaney, work like this. They have a trust that conceals the nature of the transaction, right? And then, and then the, excuse me. I'm sorry. Can you just re-ask just the last part of that question, please?
Well, it kind of actually goes to a fact issue. So let's say if we decide, yes, our common law, and for, you know, many of the reasons argued, would allow us to look to the substance of the transaction rather than the form, is there a dispute of fact here as to whether the particular way this one was set up, whether it meets the, you know, the Stoli playbook, and were there features about what actually happened here that would still weigh against us determining that this one was in violation? And part of it is the options and what Frank
I understood. Thank you so much for that clarification, Justice Devaney. Look, there's absolutely no dispute of fact here that this was a wagering contract for investors, procured by investors, funded by investors. United, just a few of the facts at a really high level. United paid all of the premiums. Garrett paid none of the premiums, received nothing in return. United controlled every aspect of this transaction. It controlled who the carrier was, what the loan amount was, how much premiums to pay, et cetera. They controlled every single one of the transaction documents that could not be altered or amended. These were boilerplate forms that Frank simply signed. And so Frank really contributed nothing except for his name, his insurability.
And more to the back end. What happens after the
Yeah, in the back end, the way all of these transactions worked, where they were designed for the purpose of creating an investment vehicle, and therefore the only real two options, Justice Devaney, were that either the investor that funded the premiums, here United, would receive what they always desired, the policy, or they would get, there is a risk they would get outbid by another investor coming in and outbidding United and therefore receiving the policy. But in either event, the policy was going to investors. And there's deposition testimony in here from the individual who helped Frank through this process at the back end, and he said there was no real discussion of him ever wanting or even contemplating, right, putting up the money for this policy. So I think that answers your question, Justice Devaney.
So we want to go back to, usually when you have a lawsuit and there's somebody engaged in wrongful conduct, if that happened in this case, there's damages. And I know your relief isn't exactly damages, and doesn't appear Jerry actually had any skin in the game or the estate has been harmed in any way that I can see. You can tell me if that's other than that. Seems like Mass Mutual, if there was anybody harmed in this case, it seems like they're the party that should be bringing this. I know some of these Stoli cases are the insurance company brings the claim and says, hey, we were defrauded and all that sort of thing. I mean, the estate's not really out anything. And I guess I think of wrongful conduct, I think of damages, and we don't really seem to have that in this case. And it almost seems like the estate's now coming in saying, yeah, somebody else made some money on it, maybe I can make some money on it. And that's one of the concerns I have in terms of just how this lawsuit is set up.
So thank you for the question, Justice Jensen. Respectfully, the estate is harmed in this case, and respectfully, Warnock, and dating back from 1800s, and was codified by this by this legislature in 1966, codified the right for the estate to bring this action. And the legislature did that for a few reasons. Right? One is to discourage these types of transactions from the very beginning. We don't want investors, right? This policy is made for investors, so we don't want them buying this up on the secondary market, creating a larger demand and therefore increasing the need to create the supply, right? And so the point of the recovery claim under 5810.5, which is statutory entitled for the estate, is that the estate is to disincentivize these types of policies altogether.
this may be a fine point, but I had a similar question on the 5810.5 statute. It doesn't articulate a theory for recovery unless you can infer, well, the theory is the statutory noncompliance, or, you know, with 3 statute, maybe that's what you get. But it says, textually, it says, may maintain an action. It seems to create an action. But it seems as though, it had me thinking, hey, does there have to be an underlying theory of recovery, fraud, there's something, or maybe it is just the statutory noncompliance with the insurable interest statute and the -3 statute. I don't know, but I thought that was weird. We have some other statutes that do that, where they just create a cause of action. They don't finish it, they just create it. And someone has to come up with a legal theory, damages, all that stuff in order to complete the arc.
Understood.
You got a red light, but I'll let you finish the question, then you can wrap up.
I'm sorry. I would, yeah, if I may, just address that briefly. So, you know, I'm sorry. Caught me a little off guard. The question.
Yeah,
and
just
I'll
that
do my
text.
best to summarize it quickly.
Maybe it's just one of those things we don't really know, and I'm putting a little bit on the spot. But just that text is a little bit interesting in the 5 statute. It may maintain an action. What is the action? Does that contemplate the sorts of things that we would usually contemplate in civil actions generally? Because this may not end it. The 5 statute may not just say, there's compliance, you're here, you just get it. Don't you have to prove damages? Don't you have to prove some other things we would expect in a darn thing, in a civil action? Just your thoughts. There's no right or wrong. I'm just kind of thinking about it.
Understood. Thank you for that clarification. So 5810.5 does create a cause of action, and the theory is lack of insurable interest. This is, you know, South Dakota is one of 27 states that have these types of statutes. Every state interprets it exactly the same way, right? The state can bring a claim, and the claim accrues at the time right at the time the state's set up, and the claim can be brought by the estate under 5810.5, and the theory is lack of insurable interest. If there is no insurable interest on the policy, then the estate is entitled to the death benefit.
Yeah, and I suppose the Froilan case would, to some extent, support that. I get that. Okay, thank
That's
you.
exactly right.
Thank you.
Thank you, Your Honors.
Mr. McLean, you may proceed with your argument.
Thank you, Your Honors. May it please the court, my name is Kai Lakwong, and I represent the appellee, Viva Capital 3. I'd first just like to say a lot of things were said that I don't think accurately reflect the record, and I'd like to address that in a little bit. But I want to start out by the hypothetical that Mr. Novi posed at the beginning of whether UNF is actually doing indirectly what it couldn't do directly. And it's not. UNF is nothing more than a lender here. UNF did not control the process, did not procure the policy, didn't even cause Mr. Garrett to procure the policy. The evidence here, and the record is clear on this, that Mr. Garrett was introduced to the idea of life insurance at the outset by attending a seminar by a life insurance agent who had nothing to do with UNF. He knew of UNF, he knew that UNF provided funding, but the spark and the plug, like the spark of this whole transaction was just Mr. Garrett on his own deciding to attend a seminar. And at that seminar, he learned about life insurance, and I suspect, although the record's not entirely clear about this, he learned about premium financing. And premium financing, funding premiums on a life insurance policy, has existed for a long time. And in fact, one justice asked the question of, is there any record as to why UNF wanted to create this in South Dakota? And it is, there's the deposition of, I think his name is Richard Kearns. Mr. Kearns was the UNF representative at a deposition, and he explained that they did go into or wanted to set this up in South Dakota mainly because of the lending laws. Because it was easier to create and get a license as a premium finance lender, and because of the usury laws in South Dakota allowed certain rates to be higher and not violate the usury laws. And the need to charge a higher rate is tied to sort of the risk that the lender is taking here. And in fact, the risk that UNF took in lending on a life insurance policy was that it's not a particularly liquid asset. And the reason that you got these new premium finance programs in the early 2000s was because there was a legitimate secondary market for life insurance. And many of the cases that the estate cites recognize this legitimate secondary market that spawned out of the AIDS epidemic, in which, you know, a lot of people were able to sell their life insurance policies.
That's life settlement. That's a totally different matter, though, than what we're talking about here. Isn't that correct?
It's very related, and I'll explain why. Okay, that life settlement market, that viatical market, created a new and vibrant and real secondary market where people could sell their life insurance even if they weren't terminally ill. And it's because of that market that life insurance became a bit more liquid and you could lend on it. And so some people in the early 2000s began to become premium finance lenders, because the asset became, if you had to foreclose on the loan, you could actually sell it into this secondary or tertiary market and not have to keep an asset that, unlike a home, if I have to foreclose on a home, I can just let it sit on a lot and I don't have to do anything. If I foreclose on a life insurance policy, I gotta keep funding premiums on it. And lenders did not want to do that. And that was in fact the testimony of Mr. Current. He said, we did not want to own policies. We were lending to lend and essentially priced the cost of our loan, which, by the way, is unlike other loans described in these cases that we talk about. He said, we needed to price this loan in a way that we were going to get at least 15, 17, 18% return, because that was the quote-unquote hurdle rate that they needed to achieve in their asset-backed loans.
Does part of this go, though, in terms of who they approve? You know, in the selection of the insured that actually enters into one of these. Because I understand everything you're saying about the need for the high interest rate and all of that, but part of that also goes to the very unlikelihood that this particular person, given their assets, their income, what have you, is going to be able to assume those premiums.
So again,
after the loan, and you know, because that's one of the things you see and that courts have looked at is they seem to be designed and targeted towards certain people that are very unlikely to ever be able to do that. So the underlying goal from the get-go is that it's going to be sold in the market to someone without an insurable interest.
Your Honor, I actually think that that is a distinguishing fact among many between this case and the other cases the estate cited. Frank Garrett, undisputably, was worth at least $20 million. He owned approximately $16 to $20 million in real estate in the heart of Silicon Valley, which I can only imagine is worth a lot more when you're planning your estate, i.e., what will you be worth when you die? So there's no question, there's no evidence that UNF targeted people who couldn't pay. The evidence is that they actually had a loan application. In the connection with the loan committal letter, there was an application submitted. It asked a whole number of questions about the insured's credit. But on top of that, the requirements with respect to the insureds are really about whether this policy is such that if we foreclose on it, it adequately secures the amount of premium that we're paying. If you lend to a borrower who's 40 years old, you will not have a policy that is worth or something that could be sold in the secondary market if you had to foreclose on it. And there's a reason for that. It's because a 40-year-old is not expected to die for 20, 30 years. And people who do legitimately buy policies in the secondary or tertiary market do not want to buy a payment stream of 30 to 40 years. And that's why the secondary market, even is the legitimate secondary market, even as it exists today, is primarily focused on older age policies. It's not anything nefarious at all. It's simply a matter of economics.
Can you just real plainly tell me what insurable interest there was here?
Absolutely.
Thank you.
There were two. So number one, there was the insurable interest of Frank Garrett in his own life. Mr. Garrett is the one who procured the policy.
How long?
Pardon, what do you mean?
Well, I guess what I'm trying to get at is he had the insurance policy was paid for him for 2 years, right? Then it was up to him whether or not he wanted to assume the payments and continue with the life insurance policy.
So this is, yes, but this is another, I think, misunderstanding or misstatement of the record, not by any fault of this court, but I think in briefing and discussion. There's no magic to 2 years in this case. The loan term in this case was 7 years. If you look at the loan commitment letter and the maturity date in the loan agreement, the maturity date was a 2013 maturity date on a 2006 loan. The premiums that were advanced were $893,000. The first 2 years of premium that were due, as stated in the loan documents, was about $671,000. So there was a loan for about 2.5 years, but that loan, or for about 2.5 years worth of premium. But Mr. Garrett and the trust did not have to pay back that loan for 7 years. The loan agreement provided that unless he died, the loan would mature upon his death. Unless he died, he had 7 years to actually.
Well, but correct me if I'm wrong, though. I'm sorry, go ahead.
That was actually one of the questions. It wasn't clear to me how this was set up. So then, you know, after the 2 years, though, he received the notification that here are your 3 options that you can proceed in. So how did that work?
I don't believe there is such a notice in this case. That, again, is a vestige of other cases that are plainly distinguishable that have 2-year loan terms. But in this case, the evidence is that after about 2 years, Mr. Frank himself hired another agent, not Mr. Weissman, but a man by the name of Bill Nowak, to help him with options. And Mr. Nowak actually, independent of UNF, independent of Mr. Weissman, who originally sold him this life insurance policy, decided to help Mr. Garrett look for other options, including selling to anybody else, not surrendering the policy to UNF. And bear in mind, the interest rate on this policy was only prime plus 5%.
But from your perspective, though, what's the relevance of the 2 years then?
I find no relevance at all.
Relevance.
The one relevance I do find is that the premiums that were advanced by UNF in this case, $893,000, would only cover up until about the middle of, so the policy and effective date of February 2008.
So is it incorrect to say that the trust owned the policy for 2 years?
The trust owned the policy for at least 3 years, over 3 years.
Over 3, no,
Yes.
but pursuant to the contract. Didn't UNF, didn't your bank, or the loan, the lender, didn't the lender take over the policy after 2 years? Or had the right to take over the policy after 2 years?
That's not accurate.
Okay.
The trust, the loan never became due until 2013.
So I just want to be clear, though. Policy becomes effective. Premiums are paid up front from the loan. When does that policy expire without any more payments? What's the date of expiration?
It doesn't expire as long as Mr. Garrett pays premiums.
No, I know, but if if he doesn't pay his own premiums after that loan is made, when does that expire?
Right. So I don't know exactly, but $893,000 was the amount of the loan. $671,000, I believe, is the amount for the first 2 years. So I'm estimating about 2.5 years. And there's a document.
So we don't really know for sure how long policy premiums were. There was sufficient funds under the loan to pay policy premiums.
Yes, UNF's loan was probably enough to pay premiums up until, there's a document, it's actually record 4266. It is a history Mass Mutual produced of premium payments. And the loan was $893,000. What this premium payment shows is by July 30, 2008, $934,000 in premium had been paid. That's more than the UNF loan. There's no record, and this is by July 30, 2008. That's when Mr. Garrett still owned the policy. The Garrett Trust still owned the policy, had full control over the policy. The UNF loan amounts had already been exhausted. So somebody other than UNF, from July 30, 2008 on, paid premiums. It was not from the UNF loans. It could have been Garrett himself. Well, he could have gotten a loan. We don't know. The other thing that I think is very important about the UNF loan is he had the right to prepay it at any time. And there was no prepayment penalty. This case is just unlike any other case that you see. The trust had absolute control. This is not about doing indirectly, but they couldn't do directly. And I'd like to come back to the question of insurable interest.
Before you,
Sure.
I just, again, on the transaction, so, a couple things. So but there did come a point where he relinquished, and it was, somewhere around that, like 2.5 year.
It was another full year.
But in order to continue with the policy, he would have had to then come up with a way to pay them himself, whether it be by an additional loan through United or someone else. But as you pointed out, the funds ran out from the initial loan at that point. And it was never clear to me from the record how the premiums were paid, whether they went directly from United to the insurance company. Did it go through the trust? I've never been able to quite parse that out.
I'm not sure. I would imagine that the loan funded the trust account and the trust paid the insurance company. But another very important factor in this case is this was fully transparent with the insurance company. So the state, there's a lot of the same cases dealing with one loan, a loan by or associated with the Coventry company. And one of the things that was notable in that case, and the Seventh Circuit case of what's called Corwell notes this, is that the Coventry loan was structured such that the loan was made to a sub-trust, and Coventry took a back-end collateral interest in the sub-trust, so that it was never known to the carrier. And that was one of the issues that they considered to make it Stoli. Here, UNF made the loan to the trust, and had the trust sign a collateral assignment on a Mass Mutual insurance company form, and recorded that collateral assignment with the carrier. The carrier was aware of the loan at all times. And in 2009, over 3 years later, when Mr. Frank surrendered the policy, also different from these other cases, they submitted a change of ownership form from the trust to Newstream, which became the successor to UNF. So it was fully transparent that the trust had surrendered the policy to the lender in this particular case. And the timing here is really important because it wasn't 2 years, and I know that term has been thrown about, or that period of time, but it was 3.5 years. The policy became effective in February of 2006. The surrender occurred in August of 2009 and actually was effected in September of 2009. By that time, according to Mass Mutual's record at 4266, by that time, approximately $1.5 million of premiums had been paid. That's.
You got your red light on. I don't know if anybody else has questions. Or if you want to wrap up.
Yeah, I'll just wrap up by saying Frank Garrett had an insurable interest in his own life. Gene Garrett had an insurable interest in Mr. Garrett's life and was without question the beneficiary of all of the death benefits at the time the policy was issued, which is what matters, and for 3.5 years after that. There is no doing indirectly what one cannot do directly here. UNF made a loan, a legitimate transaction. Frank Garrett went out and got a life insurance policy, a legitimate transaction. Two rights do not make a wrong. This is not a case in which this loan was created for UNF to take it over from the start. The terms of this loan make that clear. There's just no evidence here at all that this was rigged to go to UNF. And the last thing I'd say is the record, as Mr. Kearns showed, is when Mr. Kearns testified, is when UNF saw that there were more defaults than they wanted, They didn't, unlike other cases, they didn't like take over these policies and because they wanted to take over. They sold the notes. They sold the loans before foreclosures because they were concerned that the rest of the notes might actually result in foreclosures. And that's the record. So I think the district court was correct to rule on the plain language of the statutes, but there is no occasion here to pierce anything. You have two legitimate transactions. Together, they do not make one illegitimate transaction, and this court should affirm the lower court's ruling.
Thank you.
Thank you.
Novi, you may proceed with rebuttal.
Thank you, Your Honors. I will be brief. My friend does not truly contest the crux of the legal issue before this court is whether we should look at the substance of the transaction. It seems as though Viva is now essentially agreeing that, of course, this court must look at the substance. And now, you know, the facts are all laid out very well in the trial court, and I think, we will rest on those facts and what we put before the trial court. But just to shore up a few things, I know there were a lot of questions about this loan, so I want to address some of them. The first is, this was not a loan at all. And I know one of the questions that justices asked was, look, is this a loan? How are premiums even paid? This was not a loan because in a normal loan situation, the lender is interested in repayment from the borrower, which would require the borrower to have assets sufficient to repay the loan. Here, the lender was United and the borrower was a trust that had zero assets. United didn't care because it didn't want to get repaid on the loan. It wanted the collateral. It wanted the policy. My friend likened this to a mortgage, a foreclosure. This is nothing like that. That is a normal loan where the lender is interested in getting repaid. Here, there was no such interest. United, lent the loan to the trust, and this goes to another critical point. The trust was not this trust operated, controlled by Garrett and the family. There is in the record a specific power of attorney that grants United complete control of that trust from day one, even before the policy was issued. So,
Mr. LeQuang says there were $1.2 million in benefits paid before the policy was surrendered, or before the policy was surrendered back to the UNF, and that exceeds the amount of the loan. Accurate? Not accurate?
1.2 million was, I'm sorry?
He said that there were more premiums paid than the amount of the loan before it was surrendered. Is that accurate?
So it is accurate, and I'll tell you what the delta is. The delta is United's fee and United's attorney's fee. So he stood up here and said, look, the loan is $900,000 and the premiums were only $700,000. The record reflects on page, I just want to make sure I get this correct.
His specific representation was that money was paid as that the premium amount exceeded the amount. That's not accurate? The premium paid exceeded the amount of the loan.
That is, it exceeded the amount of the original loan, and then the lenders, the investors, had to keep paying premiums to keep the policy going until it could find another investor to buy the policy, which is what was happening.
So you're saying that wasn't paid by the trust? Is there anything that showed that the trust or someone other than the lenders paid that additional amount?
The trust had no assets. It couldn't repay anything. So it was just additional loans from United and New Street.
That's not entirely accurate. The trust did have an asset. It had the life insurance, correct?
That's correct.
And
yeah.
so are you saying that UNF then was banking on the collateral actually being liquid, and the only way you can do that is wagering on Mr. Garrett's life?
That's correct.
Okay.
Are they wagering on his life, or are they wagering with him? Or does it matter? Or against him?
I think this goes to the consent issue. I don't think it matters. But at the end of the day, if there's some hesitancy that, look, Garrett consented to this transaction, and therefore everything's okay, everything's not okay, right? The analysis is under the insurable interest statute. Consent is not enough in this context.
Of course, he could gamble on his own life.
Now, that would be a different factual scenario.
Understood.
If Mr. Garrett decided to take out a policy, pay all the premiums, do everything that's necessary to effectuate the policy, just with a subjective intent of selling the policy later. That is completely different than what we have here. That's more like our friend's cases, Kramer, Pruko, and a few others, where the policy is actually controlled by either the person or a family member. This was in a trust controlled by investors from day one. And it actually is telling. My friends can't cite a single case where in this type of factual scenario, where the trust is controlled by the underlying investor from day one, where the court did not find it was this type of Stoli transaction. And with that, I'll cede the rest of my time. Thank you.
Thank you. Thank you, counsel, for your arguments this morning. The court case is fully submitted. We'll be in recess until for about 7 minutes.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com. You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
You may be seated. Thank you. I just want to note, before we get started with our second argument, we have some students this morning from Flandreau High School. Yeah, okay, there we go. And Sioux Falls Roosevelt? All right, great. Well, good to have both schools here this morning. As we start the second case, we have Judge Jennifer Mamiga sitting with us in place of Justice Patty Devaney this morning. She's a Second Circuit judge here. We appreciate Judge Mamiga sitting with us on this case. The second appeal we will hear this morning is appeal number 31154, State of South Dakota versus Wiley Pickner. Aaron Hankey is arguing on behalf of the appellant, State of South Dakota. Not used to seeing the state on that side of the, and Justin Bell is arguing on behalf of the defendant, Mr. Pickner, the appellee. Ms. Hankey, you may proceed with your argument.
May it please the court and counsel. We are here today on a very narrow but extremely important issue. Can the circuit court grant a suspended imposition of sentence after a judgment of conviction has been entered? And the simple answer is no. It does not have the authority to do that. Wiley Pickner was convicted at trial of third-degree rape. The circuit court sentenced him to a prison term of 10 years with 7 years suspended. He served his sentence and was on parole and filed a motion to modify his sentence under 23A 31-1 or Rule 35, requesting a suspended imposition of sentence. Over the state's objection, the circuit court granted the motion and vacated the judgment, entered the suspended imp. It took Pickner off of parole and moved him over to probation. And while the circuit court does have the authority to enter suspended imps in general, in this particular situation, it does not have that authority.
Why does it not have the authority?
Because when you look at the statutory requirements, Your Honor, for what is required to enter a suspended imposition of sentence, there must be a verdict or guilty plea of a felony not punishable by life or death. The defendant could never have been convicted of a crime before, and in this particular instance, without entering a judgment of guilt, the court can enter a suspended imposition of sentence. And here the court did enter a judgment of guilt. He went to prison. And also...
Does it matter that he went to prison?
It doesn't matter. I think it adds a second layer of why this was in error, Your Honor, because, again, the defendant must be placed on probation.
So in the state's view, whether the court had initially sent the defendant to penitentiary or had suspended his sentence, put him on probation, court's without authority in either situation?
Correct, Your Honor. You have to give that suspended imposition up front, so to speak. It's not a kind of a dangling carrot like defendant behaves and does all these things and he can earn it. A suspended imposition
Where does the statute say it has to be done up front?
Because we cannot have the entering of judgment of guilt. And to place a person on probation or to send them to prison, you have that judgment of guilt.
So you kind of changed the order in the statute. I think in the 19th statute, though, it reads may without entering a judgment of guilt.
Correct.
Give a suspended imposition of sentence. You read it in the opposite direction. You can't enter a judgment of guilt. You read the statute to say there is no circumstance that the court can enter a judgment of guilt and still give a suspended imposition.
I read the statute to say the circuit court may enter a suspended imp without entering a judgment of guilt. So the may goes back to the court has the ability to enter a suspended imposition, but these are the conditions that must apply.
Makes sense, right? So you've got a valid judgment. Let's say the judgment here, as a matter of fact.
Right.
At some point, it becomes final on direct review, right? We have
Correct.
direct review, or we don't, and we get outside the cert period. We have a final valid conviction.
Correct.
If it's affirmed. And so now what? What happens, and how can, under what ways within the realm of criminal law or post-conviction relief could we conceive of a court revisiting that and saying, you know what, I'm going to take that valid conviction, I'm going to throw it away? And we know that habeas is one, DNA exoneration, whatever. This is none of those.
Correct, Your Honor. Typically, when we see a circuit court vacating a judgment, it's in that exact situation. It's a post-conviction relief type situation, and obviously, with those, there's different hearings, what have you. As far as I am aware, in this specific situation and what happened in the Pickner case, the court does not have the ability to vacate that judgment just to enter a suspended imposition of sentence.
No court does, under your theory.
Correct, Your Honor.
And maybe that's right. We'll hear from Mr. Bell and we'll put it all together. But the one thing that seems to recommend that view, at least intuitively, is that a judge does have to have some authority to throw away an otherwise valid conviction.
Correct, Your Honor. The court has to have authority, in essence, to do anything it does.
So when we're talking about timing and whether you can do it before or after, there's a larger scope issue at play, and that is the validity of that judgment. And it becomes, at some point, if not sacrosanct, at least final, and the law loves finality. It's one of the things that we're geared to do. Courts in the wheels of justice grind slowly sometimes, but when we get a result, we want it to be a pretty good result.
Correct, Your Honor. So in this situation, Mr. Pickner...
Can I ask you, though, under Rule 35, I'd just like your take on this. It says a court may reduce a sentence. How do you interpret the word reduce a sentence? Do you interpret it as simply reducing the length of the sentence or maybe even the character of the sentence? In other words, going to a suspended imp. And sorry, and I asked that in relation to the 23A-2719, which gives the courts continuing jurisdictions to suspend a sentence. And there, I think the statute specifically talks about suspending a sentence. And so it seems to me that there it talks about the length of the sentence. So why use different words? Why use suspend in one statute and reduce the sentence in the other one? What does that mean?
Well, Your Honor, so very much a reduce is less than. And in this, a suspended imposition is not a less than sentence. A suspended imposition is kind of its own animal where...
Is it not a sentence?
But you could suspend a sentence without suspending the imposition.
Correct, Your Honor. Correct, Your Honor. I'm sorry. A suspended imposition is still considered a sentence, yes, because it's a suspended imposition of sentence. And so essentially what happens is the person is, as the court knows, the person is put on probation. If you comply with the conditions of probation and whatever other terms the court places on the individual, as long as they abide by those conditions, eventually at the end, this judgment is sealed or conviction is sealed.
I question whether that's correct. So it's a suspending the imposition of a sentence, not suspending imposition of sentence. As I read the 19th statute, what the court is doing, typically courts, when they grant a suspended imposition of sentence, don't impose any sentence. That's the whole point of it. They don't say, I'm going to give you 15 years in the penitentiary, and if you do these things, you won't go to the penitentiary. They say, I'm not going to find you guilty. I'm going to impose conditions for you, and if you don't comply with the conditions, then I will impose a sentence.
Correct. Usually they're placed on probation during that interim period.
So suspending the imposition of a sentence is not a sentence in my mind. Am I wrong about that? You just said the opposite.
No, I don't think you're wrong, Your Honor. Like I said, a suspended imp is a completely nuanced thing. It's not simply a suspended sentence, as Justice Kaczynski was asking about just a second ago. Again, with the suspended sentence, usually there is, as you were just talking about, Justice Myron, a term of years with, like in this instance, it was 10 years with 7 years suspended. That's the suspended portion.
Mr. Pickner's original motion was under, I think, 31.1.1. I think it was only under the 23A 31.1 statute. Later, the arguments between counsel morphed into also including the 23A 27.19 statute. But I think the original one was aimed at this type of sentence, his original motion was aimed at this type of sentence, not the idea of the suspended imposition.
So his original motion was, I believe, I can't remember the exact title, but it was something along the lines of motion to modify. He does cite to 23A 31.1, and in that motion, he specifically asks for a suspended imposition of sentence. He does not ask for a reduction of sentence. His request is that suspended imposition.
Question is an important one, because as Mr. Bell points out in his brief, we're here not from the order that would vacated the original sentence and ordered the suspended imposition. We're here on your motion to correct a sentence.
Correct, Your Honor.
Mr. Bell makes an argument, and you gotta, either it's a sentence or it's not a sentence, because we're here on the strength of an argument that the state is seeking to correct a sentence. If this is not a sentence, there's no sentence to correct, illegal or otherwise.
Right, I understand what you're asking.
We had this earlier. We had an effort by the state to directly appeal this case, and the court divided on that, but 3 members of the court said, this is not a direct appeal. And so we're back, and now on the strength of an intermediate appeal, but I wonder if that earlier proceeding or that earlier appeal dismissal doesn't live on a little bit and manifest itself in Mr. Bell's argument.
I'm not sure I understand what you're asking.
Why are we here? Why does the state have appellate jurisdiction? Why can the state come in and seek to correct a sentence based on illegality when it's really not a sentence at all? It's the absence of a sentence. It is the suspended imposition of a sentence. A sentence accompanies a conviction that then ripens into a valid judgment of conviction. We don't have that. That's gone. We have only the suspended imposition of sentence, which is not a sentence. It may have conditions and look in some ways like a sentence. It is not, in my mind.
In absence of a sentence, as you were saying, Your Honor, it's still the court handing down the discipline, so to speak, for the defendant.
I'm sorry, forgive me. This has to matter, though, because there has to be a difference, and I think that the statutes really get at this. There's a difference between the suspended execution of a sentence.
Yes,
that
Your
is a
Honor.
sentence.
Correct.
There's a conviction. And the suspended imposition of a sentence, which may in some ways look like it. But the whole point of the latter is that the record's sealed, there's never a sentence imposed, there's never a valid conviction of judgment, and in some ways that is good for the applicant, right? Because then they avoid the stigma of that conviction, and that's why those statutes probably exist. We can agree on that, I hope.
Yes.
But they're vastly different.
Yes, they are different, Your Honor.
And you're here asking, under the strength of 23A 31.1, asking to correct a sentence which I'm not sure exists anymore. Because you lost on the effort to appeal directly.
Correct.
So how do we get at this on the merits?
I think, again, absence of a sentence is still a sentence. It wasn't like this is a situation where the defendant was found not guilty. There is no finding of guilt. We still have whether absence of sentence or sentence, it's still a sentencing mechanism. The person still has conditions imposed upon them that they must comply with. It's not like the individual is
What's
free to go
What's
about.
illegal about that?
I'm sorry, what's
What's
that?
illegal about that?
It's illegal because the court didn't have authority to do what it did.
Which may not even be a sentence. And I know we're kind of going around and around.
So
but
if Justice Salter is correct, he's essentially saying that we were incorrect in dismissing the original appeal, and based on that premise, the state's being denied the opportunity to ever have raised the issue that it was entitled to raise in the first instance.
That would be correct, Your Honor. I mean, if this court determines that the state's doesn't have the ability to appeal this suspended imposition, and the state didn't have the ability to appeal the initial motion to reconsider order, then the state is without recourse, and the circuit courts essentially have unchecked authority then, or unchecked ability to go ahead and enter sentences or non-sentences without any recourse.
Ordinarily, the state doesn't have the right to appeal a sentence.
Correct, but it does have specific, again, we have the ability to appeal an illegal sentence.
You have the ability to file a motion under the 31-1
Yes,
statute.
we can ask for a discretionary appeal, excuse me, I'm sorry, Your Honor.
No, under the 31-1 statute, you have the ability to do what you did in this case, which is to go to the court and say, you have imposed an illegal sentence, and we want you to review that issue. The court reviews that, and then the argument perhaps would be that upon a denial of that type of motion, then we should have the appeal of right. Even though we wouldn't ordinarily be able to appeal the sentence, you should be able to appeal that.
Correct, Your Honor.
So a suspended imposition can only be entered if the defendant does not have a felony conviction, is that correct?
Correct, Your Honor.
In this case, he did have a felony conviction, technically.
He technically did, which was the conviction from it within this case, yes, Your Honor.
he totally did.
He
There's really
did,
nothing
yes, he
technical
went to
about it.
prison, he went to prison, he has that conviction.
Even if he didn't go to prison.
Correct.
He really has a conviction.
Yes, he does, which again was then vacated by the circuit court. I will yield the rest of my argument to my rebuttal. Thank you.
Thank you. Mr. Bell, you may proceed with your argument.
Mr. Bell, is a suspended imposition of sentence a sentence in and of itself?
May it please the court, counsel, to answer your question, Justice Salter, I think that's a question. Let me back up. My position is it is a sentence. I don't know if the answer makes it makes a difference as to how the court gets to its decision. I don't think it makes a difference as to whether or not Mr. Pickner should win this appeal. And it goes to maybe, and certainly ask questions if you want, but I think to frame the issue, I think there's really three issues before the court.
Before you get there.
Yeah.
Is a suspended imposition of sentence a sentence itself?
I think there's case law that would indicate that it is, Justice Salter. The reason I would say that is that this court has authorized an appeal from an order granting suspended imposition of sentence, and in that case law, it essentially calls it a sentence that can be appealed. I understand the rationale that you and Justice Myron said, which is it's not really a sentence, it's a separate order that is pending the sentence.
It seems fundamental to the whole idea that we can seal it, and then no one ever sees it. And that's the whole nature of the relief. So that seems like an important part.
Your Honor, or Justice Salter, I would agree it's important. I think the court addressed that in part in the State versus Anderson decision and in Conway versus Hughes, which are 100-year-old cases, but they did discuss this. Those cases talk about the difference about a suspended imposition of sentence and a suspended execution of sentence, and whether or not the constitutional provisions and statutory provisions, which are different than what we have today but are similar, grant that authority. And in the Anderson case, I read it to state that the word suspend in the original statute that was used encompasses both the ability to suspend execution and to suspend imposition of the case of it. in Conway versus Hughes, they don't necessarily answer the question, not Conway versus, excuse me, make sure I'm citing the right case before I go too far. Yeah, excuse me, Conway, Attorney General Conway versus Judge Hughes. They discuss that as well. And I will kind of back up, and maybe I should say that, and it kind of gets to where I'm going at with that is, as to the last issue, is a Rule 35 motion.
It's your last issue.
What's that?
It's your last issue.
Yes, excuse me. My third issue that I raise is a Rule 35 motion the appropriate mechanism to do this? And I would answer the question, or answer that question is no, for one of two reasons, and it depends on how the court gets there. If it's not a sentence, you can't use a Rule 35 motion to correct an illegal sentence.
Well, that was kind of what I thought your argument was.
What's that?
That was, I thought what your argument was.
Yeah, it is. It certainly is. It's one basis by which it can be. The other basis.
That's a kill shot if you win on that.
Correct. I agree. I mean, and I think that's a very valid reason. And to the argument that the AG's office has is, well, we don't have any recourse if that's the case, I would respond with that with two reasons. One is that's pretty common in the criminal system. There's final judgments, and the legislature has not granted the state the right to appeal. They do have a recourse in that situation if that's what the court holds. That recourse is to go to the state legislature and ask for the legislature to grant them the authority to appeal in those situations.
It really feels inappropriate to think that the state has no recourse to bring to the court a challenge to the court's authority to actually do something that it's doing. To say the court can't do it, because when I first became a judge, the very first rule first advice I was given was, as a judge, people are going to ask you to do things, and your first question should be, where do I get the authority to do that? And that's the precise question that the state has brought to us is, where did the circuit court get the authority to do this, which is kind of a clemency, really. What you asked is, you said under 31, find me not guilty now, even though you found me guilty before.
I would respectfully disagree that it's clemency. We'll get to that in a second. But I don't disagree. I mean, it does seem harsh that we would just say you don't have any right to appeal that. There are situations where that is the case, but I think more importantly...
Can you think of another instance where a court can take an otherwise valid final judgment that has been passed upon by an appellate court, and any error is adjudicated as not erroneous or harmless, and you have a righteous conviction for all the world right there as a matter of record? Can you think of any other instance where a court can just say, you know what, I'm going to throw that out? And there's no appeal. The state can't say boo about it, and there was nothing wrong with this conviction. Nothing.
Justice Salter, I think the answer is I cannot think of a situation where you just completely throw away a conviction. I will say this, though. I don't think that a suspended imposition of sentence based off of our state statutes is a throwaway of a conviction. I don't think it's clemency. I would submit it's not part. And to go back to Justice Myron's question, I do want to answer the second part of that, though, is there is a remedy. It's the remedy that the AG's office used for 30 years regularly in the 19-teens, 1920s, 1930s, and 1940s. It's the remedy that we used in Hughes versus Conway. The correct method by which the state should have handled this is through a writ. The answer is to bring a writ of prohibition or a writ of certiorari to the Supreme Court in an original proceeding saying that the circuit court does not have the authority to do that. And it could have. That's how the court regularly resolved these situations in the 19-teens and 1920s. They abandoned that. They waived their right to do that by letting the court move forward with this. Had they brought a writ of prohibition, that's one, there could have been a writ of cert, but let's say that they would have brought a writ of prohibition during the pendency of this motion before Judge Mayer made the decision. Procedurally, they could have done that. And the AG's office has done that dozens of times if you go through the court's history on the litigation of these situations, because this was a major issue to the state in the 19-teens all the way through 1940s and all the way up to 1974 when we amended the Article 5, Section 5 of the Constitution for a third time. That's the proper remedy to do this. I mean, that is the procedure that should have happened, and it's not what was done in this
So thank you
case.
for that. But let's go back to the other point that you stepped away from, which is the idea of getting away from the finality of a judgment. You agree that what you're asking for, the only way the court could give what you were asking for is to vacate the judgment of conviction?
I think it's modifying the judgment or an order, a judgment. I think an order granting a suspended is a judgment. Whether or not it's a sentence or not is a separate question, but it is a judgment.
What's a judgment? I'm sorry.
An order granting a suspended imposition of sentence as it relates to it. I think it is a modification of a judgment, taking away the finding of guilt and imposing, and you can only do it for 2 years. I mean, there is still, regardless of a position that one takes on my client's position or these situations, this is a regular tool that circuit courts in the state use. In the last 5 years, it's been done roughly 1,000 times throughout the state, based off of information in the record from the court administrator's office. There is a finality to it, and if you whether you look at, I refer to it as Rule 35, that's one of the sub-notes of it, of the -1 or the -18 SDCL. There's a 2-year limitation where the court has jurisdiction, and I think that is the rationale for that is based off of the Article 5, Section 5 language that we currently have, and it's based off of the rationale that, for example, the Supreme Court used in the Hughes versus Conway case, which says as long as the state legislature has indicated that the court still has jurisdiction of the case, it's not final, it's not forever. At the time that we were dealing with in the 1930s, it was actually only 30 days because the state had not passed a 2-year look-back period that we have now. They said you can do it for 30 days after, well, there's still, the circuit court has jurisdiction prior to the appeal. Actually, I don't know if it's 30, it might have been 60 days, at that time. It's whatever the timeline was for the file a notice of appeal at those time frames. I think we switched.
So under
from
that
60
theory,
to-
then the 2 years, so the premise that I was sort of operating under with some of my questions was, this is final. It's final on direct review. You're outside the cert period to go to the Supreme Court, and certainly for post-conviction, that is universally regarded as the test for finality. Your view is it's really not final until the 2 years.
Correct, and I think that is true if the court does not have, if it's true that a final judgment is a final judgment, you can't change it, it's final, then the entire process by which you can amend a judgment at all goes away. Then there's no ability to even suspend execution of a judgment for those. If you don't have jurisdiction, you don't have jurisdiction, Your Honor. If you don't have the ability to do anything because it's a final judgment, and Article 5, Section 5 doesn't extend that. Now, that's not my position, but if the logical conclusion of the fact of saying you can't change a conviction because you don't have jurisdiction outside of after you make a...
Well, then I think you get into the details in the text of the rule. As Justice Kaczynski was sort of questioning about, do you have eligibility criteria that matches? Does this work? Is this what the legislature requires? Certainly the legislature probably, as it has done, would have the authority to say, no, in some instances, you do have a final judgment, but in some instances, exceptionally, we're going to allow the court the authority. I don't know that that means it's not final, but they just have specific authority within a window of time to do something, whatever you want to call it. But then there's a question, I suppose, once you go down that road about eligibility, what's the final conviction mean? Is it really a felony conviction? Is it disqualifying, and all of those sorts of things?
Your Honor, and I understand. As to the eligibility question there, I would say I think that by modifying the judgment, taking away the finding of guilt, you are eligible as it relates to the situation. But I agree. You have, there's eligibility. That's one of the factors you would look at as it relates to that. I would submit, though, that one would have. So,
your original motion came under 23A31.1. And then later, as the arguments developed, the court also brought into it as its source of authority possibly 23A 2719. Tell me which one is the cleanest source of authority from your point of view, the one that you would rely upon?
Your Honor, trial counsel brought one based off of, you're right, -1, just a motion to modify the sentence. I think in argument, he kind of supplemented that by also talking about the motion to suspend. I think both of them grant the authority to do what we're talking about here. I think actually that the Rule 35 is probably the stronger argument based off of the rationale in the Anderson case, which said that the word suspend includes both the power to suspend imposition and to suspend execution of a sentence. But I think you can also get there by saying that you have the authority to reduce a sentence. I think that, of course, that gets into the question, is it a sentence at all as it relates to it? But if it's not a sentence, I don't think Rule 35 is an appropriate remedy for it. But I think you can do it either way. I think the -1 mechanism, or Rule 35 as I've referred to it, and it's referred to in code, is one mechanism. I think the cleaner actually is because I think case law of this court says that the word suspend in those statutes includes both the power to suspend imposition and suspend execution, but to answer your question. But either way, it gives the trial court authority to suspend imposition of sentence, which is extremely broad. And quite frankly, I think it's important to remember that the position that the AG is taking is the exact position that the AG took in 1921 when the court decided State versus Anderson, and the people of this state amended the Constitution explicitly to grant the authority to do this thereafter. And then it was the Conway versus Hughes case where they said that State versus Anderson was abrogated based off of the amendments to Article 5, Section 5 of the state constitution. And then in 1974, when we rewrote a substantial number of the UJS provisions in the Constitution, it was even broader to give a circuit court judge or a trial court judge the authority to suspend a sentence unless prohibited by the legislature. The 1930 was to essentially say that as long as the legislature authorizes it, it was allowed to. In this case, though that's certainly not barred by the legislature. In fact, I would submit that both Rule 35 and -19 statute give a circuit court the authority to do this. So, Your Honors, with that, I would simply state that one, I don't think Rule 35 is the appropriate mechanism. The appropriate mechanism to do this would have been a writ. They didn't do that. They've waived their authority to. I would submit that this is a commonly used tool for circuit court judges to encourage behavior and to make sure that there's reformation, which is really why we're here.
But
client.
What about that? I'm sorry, forgive me for interrupting, but what about that? You know, you're right. I mean, this is widely done. Judges throughout the state have done it, you know, since, I don't know when, for a long time. And you know, we also had, and I know you do some federal work, we also had the sentencing guidelines for 18 years, and we thought they were mandatory, and they weren't. And thousands of federal defendants were sentenced under the mandatory federal guidelines, which we now know, 18 years later, violated the Sixth Amendment right to a jury trial. So what effect do we give to current conventions or practices or things that might be disrupted as a result of a decision that's adverse to you in this case?
I see my time's
on. You can answer the question.
I think that, as I would see it, I mean, certainly what circuit court practice is not binding on this court. I do think it's something that can be informative to the court as to whether or not this is a legal sentence, which I think is a pretty, maybe it's persuasive authority to the court as it relates to it. I don't think that based off of it being common practice that is binding upon the court. The only other thing would be, I mean, if a Rule 35 and it's an illegal sentence is there, and that's the proper way to challenge this, we're looking at tens of thousands of potential cases this court is going to potentially be looking at, because if in 4 years there were 1,000 cases, or 5 years, excuse me, there were roughly 1,000 cases. There's probably a lot of other people out there who are in similar situations where this court would have to, or the circuit courts at least, and potentially this court would have to go through and determine how many of those cases are actually valid sentences. But I think, and that same practice happened after the mandatory nature of the guidelines went away, and there were a lot of Rule 35 motions based off of that as well. So, but I think really it's just a question of it being persuasive authority on the court. The circuit courts have been doing this. Thank you.
Thank you, Mr. Bell. Thank you. You may proceed with rebuttal.
Justice Salter, to answer your question you had just asked Mr. Bell, frequency of use across the state does not equal legality. So just because it is happening with frequency across the state does not make what happened in Pickner's situation a legal sentence.
So maybe you're not aware of this, but I can't tell you how many times the Attorney General's office actually at sentencing has, responded to a suspended imposition request by saying, have him prove it, or have her prove it. So that's a little different than the circuit court simply doing it wrong. That's the Attorney General's office actually encouraging and saying that this is the way to do it. And maybe it doesn't matter in this case, but I'd like to hear your answer on that.
I will say, Your Honor, I do know, I think this was even addressed at the circuit court level with one of my colleagues served as the prosecutor in this matter. And my colleague did fall on her sword and say, Your Honor, I realize I have asked for this before. My eyes are open. I see now that this is not appropriate. And so I would just submit to you, Your Honor, that sometimes with age comes knowledge. Sometimes the longer we practice, we kind of see the error of our ways. There's the old adage, it's called the practice of law, because we're constantly learning. It's not something you can perfect. And so if the Attorney General's office has asked for that in the past, that very well may be, and I'm not going to disagree with you, Your Honor. What I'm saying now is we've seen the light. We understand that the statutes really don't allow for this type of sentencing mechanism. And so moving forward, we'd like to go about the appropriate way.
So along with that lessons learned type approach, Mr. Bell suggests that the appropriate remedy for you here was, at the time the judge undertook this modification of sentence, or was approaching it, you should have filed a writ of prohibition with the court saying, she can't do this. She doesn't have the authority to do this. She is legally prohibited from doing this. You should direct her not to do this.
Certainly, Your Honor, that was an option. I can't speak to why that option was not taken.
But that seems to deflate your argument that we have no remedy if you just acknowledge that it wasn't, in fact, an option.
And that's if this court decides to take up that writ as well. I mean, it's not a straight shot to this court. It's still, hey, court, look at this issue.
Well, intermediate appeal wasn't a straight shot either.
Fair,
You had to ask
fair,
for
Your
permission
Honor.
and get it.
Except the earlier one would have been.
Correct. The original,
But you
or
didn't
our
have
first,
votes.
I should say, not the original, but the first, we did a notice of appeal, a direct appeal, and we were shot down by that.
But perhaps it points to the fact that maybe the court was right in denying the direct appeal, or dismissing the direct appeal, because in fact you have another remedy that was available, which was the writ of prohibition.
Perhaps, Your Honor, but we're here now on a motion to correct, or the denial of a motion to correct an illegal sentence. And going back to that point, both you and Justice Salter had asked, both of myself and Mr. Bell, is this truly a sentence that can be, is it a sentence? Is it suspended imposition of the sentence? So is it a sentence? And as I pondered while Mr. Bell was speaking and listening to what he had to say, I agree with him. I do think the suspended imposition of the sentence is still a sentence. There is still this thing out there that does put conditions on the defendant. If the defendant doesn't comply, there is a judgment of conviction ordered. So
what are you suspending the imposition of, if this is still a sentence?
It's still a sentence until, I would say it's a sentence until that file is sealed.
So if the defendant fails to comply with the conditions of the suspended imposition of sentence, then it comes back to the court on a revocation hearing, correct?
Correct, Your Honor.
And there's due process involved.
Correct.
Why is there, what are we revoking at that point?
You're revoking that order suspending imposition of sentence and entering a judgment of conviction and whatever else may go along with that. This case turns on a simple but critical point. A circuit court cannot undo a final conviction and grant a suspended imposition of sentence after a defendant has already been sentenced to prison and served that sentence, which leads to one result, that the suspended imposition in this case must be vacated and the original sentence reinstated. Thank you.
Thank you. Thank you, counsel, for your arguments this morning. The case is fully submitted. We'll be in recess for about 5 minutes.
You're listening to oral arguments of the South Dakota Supreme Court. The court is in recess and will resume shortly. For more information about the court, please log on to www.sdjudicial.com.
be seated. Thank you. All right, the last case set for argument this morning is Save Centennial Valley Association versus Brenda